Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, as you know, for those of you who are geeking out on this channel, there are a lot of huge Second Amendment issues that are really about to kind of come to a head. We're about to have the final battle royale. We've already had Rahimi argued before the United States Supreme Court. We're going to get a ruling on that. We already had Cargill argued in front of the United States Supreme Court. We're going to get a ruling on that as well. But you remember another rule from the ATF? Remember when they thought that they could regulate, just chunks of aluminum? Their rule on unfinished frames and receivers? Yeah, you remember that? And then you remember how the Fifth Circuit basically threw that rule out on its ass? Yeah, I remember that too. Well, now, as you recall, the United States government is asking the United States Supreme Court to accept review of that. The case now is called Garland v. VanDerStock, and there is a huge date coming up, April 12th, because on April 12th, all the justices are going to be getting together. They're going to be meeting about many things. One of the things they're going to be meeting about is, are they going to accept review of this case? This case has the potential to be absolutely huge, and it really has nothing to do with unfinished frames and receivers. I'll explain in just a moment. So today, let's spend a few minutes and let's talk about the huge decision the Supreme Court has to make this month. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Right to Bear. That's right, legal protection for self-protection. Listen, good lawyers aren't cheap, cheap lawyers aren't good. You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, so the case we're talking about is now called Garland v. VanDerStock. Used to be called VanDerStock v. Garland. It is a case brought to us by our good friends at the Firearms Policy Coalition. We will put a link down below if you want to show them some love. This is a challenge to ATF's rules on frames and receivers, i.e. that the ATF believed that they could just start regulating raw material, chunks of aluminum and things such as that, despite the fact that there was no act of Congress whatsoever. Now, as we know, the Fifth Circuit was not very impressed with this rule and has in fact thrown the rule out. The United States government, the Department of Justice, is asking the Supreme Court to accept review. That decision as to whether or not review is going to be accepted is going to be made on April 12th. Let's go back over the respondent's brief, that is the brief on behalf of Ms. VanDerStock, done by the Firearms Policy Coalition, because they agree about one thing. And the one thing they do agree about is yes, the Supreme Court should in fact accept review of this. That's where their agreement parts. The United States government is asking for the Supreme Court to overturn the Fifth Circuit. Firearms Policy Coalition saying, nope, Fifth Circuit got it exactly right. It should be affirmed. Now, for those of you who geek out with us regularly, you know that I love to go over the questions presented, because I'm sure if we read the Department of Justice's, the questions presented are going to be something along the line of whether or not there should be millions and millions of ghost guns onto the streets causing havoc and death and destruction everywhere. The Firearms Policy Coalition, however, frames the issue legally and constitutionally properly as follows. 1, whether an item that is not a functional frame or receiver, but merely may be manufactured into one by a purchaser, is a firearm under federal law. 2, whether a weapons part kit may be considered a firearm, even though Congress expressly excluded from its definition any weapons parts other than a frame or receiver, and the newly regulated kits lack a frame or receiver. And so there are two issues here. Number one, the ATF's regulation of 80% lowers unfinished frames and receivers, raw chunks of material, despite an act of Congress never occurring, and their regulation of parts kits, which they also believe, standing alone, constitute a firearm, despite the fact that Congress has never defined it that way. Now, I mentioned that there was some agreement, and the agreement between the parties is, yes, the United States Supreme Court should in fact accept this case, as FPC points out. Respondents agree with the government on the proper disposition of the government's petition for a writ of certiorari. This court should grant the government's petition to determine once and for all whether ATF's rule expanding the definition of firearm to include weapon parts, kits, and items that with additional manufacturing could become frames and receivers is consistent with the definition of firearm in the Gun Control Act of 1968. And ultimately, that's what this all comes down to, people, is does an unfinished frame or receiver or a weapon parts kit fall under the definition of a firearm as articulated in the Gun Control Act of 1968? The Fifth Circuit has already properly ruled, no, it does not. Congress could have changed the definition of firearm, could have added some additional language about frames and receivers to allow ATF to do this, but last time we checked, Congress has taken no action. While the respondents agree that certiorari should be granted, that is where their agreement with the government ends. That is because the challenge provisions of the rule are fundamentally incompatible with the Gun Control Act's definition of firearm. Now, one of the things that the ATF traditionally does is shoot themselves in the foot over and over and over by announcing that these types of regulations and rulemaking is really not about saving lives, it's just about driving certain people out of business. Don't believe me? Well, one of the things that FPC points out in their memorandum here, the expected result of ATF's rule was not simply to regulate this industry, but to destroy it. ATF informed the FBI that the rule should not be expected to significantly impact the background check system because many part kits manufacturers and dealers will just go out of business. Now, for as much as the government wants to finagle and come up with all of these other creative little arguments, which we will get to, the point to be made here is really one that's just grounded in simple English, okay? Because as the respondents point out, a frame or receiver simply is an item that can function as a frame or receiver. An item that must be converted to function as a frame or receiver is not itself a frame or receiver in ordinary parlance. Now, as we mentioned, what the respondent is arguing is hey, yes, Supreme Court, accept the review and then rubber stamp what the Fifth Circuit ruled. Because as FPC points out, the decision below is correct and the rule is an invalid exercise of agency authority. The items newly regulated by the rule are not frames or receivers. And again, we come back to just simple English to define what's occurring here. Simply put, if an item potentially could be made into a frame or receiver, but is not a frame or receiver, that item is not a firearm under the Act's plain text. And see, what's happening here is the ATF wants to have it both ways. They're saying, well, these aren't frames and receivers, but they're so close to being frames and receivers that candidly we have the authority to regulate that as well. Again, without any act of Congress. And that's what makes this case so critical. It's very similar to the Loper-Bright case. It's very similar to the Cargill case. This is about limiting administrative agency action. The Fifth Circuit below held by greatly expanding the universe of items that could be considered a frame or receiver, the rule effectuated an impermissible extension of statutory text. A part cannot be both not yet a receiver and a receiver at the same time, and although Congress could have regulated such items as firearms under the Act, it did not, and ATF is not free to expand the scope of the Gun Control Act without Congress's blessings. Now, one of the arguments that the government tries to use is, well, it's this ordinary usage of the English language because, listen, these 80% lowers are frames or receivers because that's how we're referring to it. And they come up with some really goofy examples, the first of which was a bike, which is, hey, listen, if we have a bike and it doesn't have pedals or a chain or things like that, it's still a bike. FPC correctly pointed out that's not quite the analogy you should be using. The government argues that ordinary usage supports its rule, suggesting that the new definition captures what is ordinarily understood to be a frame or receiver anyway, and analogizes to bicycles, noting that a bicycle is still a bicycle even if it lacks pedals, a chain, or some other component needed to render it complete. As an initial matter, this is an apples to oranges comparison as the analogy concerns the bicycle itself, not the frame of the bicycle. And yes, let's also remember that a bicycle that has no frame is not a bicycle. So if you have all the other parts, the pedal, the seat, you name it, everything you need, but you don't have the frame, then you don't have a bicycle. Similar to what we're talking about here, because when you don't have a frame or a receiver, you don't have a firearm. What FPC points out is, hey, listen, There are 4 ways that a thing can become a firearm. They're pretty well articulated. It's just that these unfinished frames and receivers aren't falling under any one of them. As they point out, the government's analogy, in addition to failing to advance its case on its own terms, also fails to account for the statutory context in which the terms frame and receiver appear. Though the government appeals to the ordinary usage of the term, to speak of ordinary usage of frame or receiver is to miss the point. The key question in this case is, what is a firearm? Congress has defined it to be, for these purposes, one of only 4 things. 1. Any weapon that fires a projectile by means of an explosive. 2. Any weapon that is designed to do so. 3. Any weapon that can be readily converted to do so. Or 4. The frame or receiver of any weapon in the prior 3 categories. And because an unfinished frame or receiver, a chunk of polymer, a chunk of aluminum does not constitute any one of those, it cannot be regulated by the ATF because it is not a firearm. Put other ways, in sum, a frame or receiver simply is an item that can function as a frame or receiver, not an item that can be converted to do so. The government disputes this reading, arguing that the rules merely defines the point in the manufacturing process at which an item becomes a frame or receiver. But later in the same paragraph, it emphasizes that the rule covers partially complete frames or receivers. Even saying such a thing, the rule treats partially complete frames and receivers as frames or receivers proves the logical inconsistency in the government's position. Now, the government also likes to use the IKEA bookshelf as a reason for why parts kits should be regulated. And there was all sorts of problems with the ATF's attempt to regulate these parts kits. We'll get to a couple of them in a moment here. But they're basically saying, hey, listen, an IKEA bookshelf, even though it comes in pieces in a box, is still a bookshelf. As FPC, however, pointed out, in contradiction to that, the government's attempt to analogize parts kits to an IKEA bookshelf fails for the same reason. An IKEA bookshelf is shipped with all the completed parts necessary to build a bookshelf, whereas a parts kit requires manufacturing of at least the key component to become a firearm. A better analogy would be a Pinewood Derby car kit that comes with wheels, nails to affix them, and a block of wood that must be carved and sanded before it can become a car. No one would call such a kit a car because the central component must still be manufactured to turn it into a car. So too here, where the key component of any parts kit regulated by the rule necessarily has yet to be completed. And of course, if you allow a rule that is so gray and so many different shades of gray with no bright line rules, you basically allow the government to, well, what they do often, make up the rules as they go along. As FPC points out, the rule threatens to render the Gun Control Act unconstitutionally vague by making it unclear when an item that with some work could become a frame or receiver crosses the line to become a frame or receiver, or when a weapon parts kit is sufficiently complete to be a firearm. And that raises another issue about the weapons part kit. And we pointed this out the minute this rule came out, is they were relying on marketing material, and then they were also relying on, were there any jigs, tools, and other instructions sold with it? Now, we pointed out, are you saying that it has to be sold with it? Because a lot of these companies would have been smart to bifurcate it and sell the raw material in one location and sell all the needed tools and instructions on how to mill it out somewhere else. FPC put it this way. In other words, whether an item or parts kit is a firearm and therefore regulated under the Gun Control Act depends in part on the marketing materials and tools with which it is packaged. The same parts sold in different contexts may be regulated in some, but not regulated in others. If two companies decide to each sell half of a kit, with one selling a receiver blank and the other selling a jig and tools, none of it would be regulated, while if one company sells these items together, all of its components are regulated together. Such a regulation, with criminal consequences, essentially creates a trap for the unwary. Okay, so the case once again is Garland v. VanDerStock. It is before the United States Supreme Court on April 12th in a committee meeting to see whether or not we will actually have acceptance by the United States Supreme Court for next year's term for oral argument. This is a case that has the potential to be really, really huge, and once again destroy multiple pages in ATF's playbook. Listen, we'll go ahead and link up the memorandum down below so that you can geek out on it for yourself. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.